and I serve as the director of the ABA Commission on Immigration. We are thrilled to present this timely webinar brought to you by the ABA Commission on Immigration and the Section of Civil Rights and Social Justice, entitled Chevron Sleeps with the Fishes, Immigration, Environmental Law, and Much More After Loper Bright. The ABA is actively planning additional programming on a variety of topics, so please visit our website for updates on these programs. During today's program, we encourage you to ask questions of our panelists through the Q&A and not the chat function. If you do not see the controls, please ensure that your screen is not idle. We will be monitoring the Q&A and will do our best to answer your questions, time permitting. We will share the recording of this program with everyone who is registered, so please share widely with your networks. In addition, we encourage you to become a member of the ABA if you aren't already. There are many benefits to being an ABA member, including joining like-minded professionals to build your network, supporting the ABA's mission of defending liberty and pursuing justice, other tangible benefits like free CLE programming and discounts on national brands. ABA members also have the opportunity to join entities like the ABA Commission on Immigration, which provides you with opportunities for pro bono service, education on immigration, and a platform for national advocacy work. I will now turn the program over to Kevin A. Gregg, a Commission on Immigration member and partner at Kurzban, Tetzeli, and Pratt, and perhaps most famously, the host of the Immigration Review podcast, a weekly podcast of precedential immigration decisions, who will now introduce our speakers. Kevin, take it away.
Thank you, Meredith. You are far too kind. I really appreciate it. And I'm honored to be here, let's be honest, punching above my weight and whatnot with some administrative law scholars. I have the honor of introducing our panelists and asking them a bunch of questions today. And we're going to talk environmental law, administrative law generally, Loper Bright, and some immigration law, in addition to other things. You can learn all about Professor Jack Beermann and Barry Hartman in the links provided in the flyer, but to sum it up briefly, Jack M. Beermann is a Philip S. Beck Professor of Law and Professor of Political Science at Boston University School of Law. His scholarship focuses on two primary areas, civil rights litigation and administrative law. He has co-authored many books and legal articles on administrative law and teaches that course, along with others at Boston University, my alma mater, no less. Thank you for being with us today, Professor.
You're welcome.
Barry Hartman is a partner at K&L Gates, LLP. At that firm, and among many other things, he represents companies and individuals in criminal and civil investigations, trials, and appeals, primarily involving complex federal regulatory programs with an emphasis on environmental matters, and he advises clients on compliance with those programs. He's been litigating in the world of administrative law for a long time, pre-Chevron, as he didn't want me to say, but it's so relevant, right? Both within the government and in the private sector, including on complex issues of environmental law. So thank you for being with us today, Barry.
It's my pleasure. Thank you.
We're having this conversation today because, as hopefully everybody knows on the observing the panel, the Supreme Court overturned Chevron at the end of its term this year in the Loper Bright decision. I think we need a bit of a lay of the land, though, before we dive deep into what all of that means. So, Professor Beermann, if you could be so kind, could you give us like a 5 to 10 minute rundown of administrative law, the Chevron doctrine, and a bit of the history of that decision, really like half of your admin law class in 5 minutes?
Okay, this is, I guess, Father Guido Sarducci used to give the 10-minute university. So,
okay.
But you know, I want to start out by just saying that this, what's going on in administrative law these days is really impressive. And the Supreme Court is making major moves, along with some of the courts of appeals, to really tamp down on the power and discretion of administrative agencies. And I know that, you know, the Chevron, overruling Chevron got a lot of coverage. People think it's a major thing. I don't know if you've seen the movie Airplane.
I have.
But you remember in Airplane, there, you know, all these things are going wrong. The hydraulics are gone. The pilot is unconscious. The engines are gone. And everyone sort of sits calmly. And then when they say the coffee is out, people panic. You know, and I feel like the overruling of Chevron is a little bit like the plane without the coffee. It's really not. It's a symptom of something much bigger than just the end of Chevron. But I'm gonna go over really quickly the history of Chevron deference and mention a few points about Loper Bright, and hopefully you tell me if I'm going too long.
Well, before you
So-
do, just don't call me Shirley.
Okay, I won't.
All right.
I won't. I do, Jeff. So, when Chevron was decided back in 1984, it was startling at the time, but really in retrospect, it shouldn't have been, because there were precursors between the adoption of the Administrative Procedure Act in 1946 and the Chevron decision in 1984, in which the Supreme Court and lower courts said that when there's an issue of statutory construction that's within the expertise of agencies, that there ought to be a lot of attention paid to what the agency says the statute means. And Chevron itself wasn't considered that big of a deal when it was issued, until some of the lower courts, mainly the DC Circuit, figured out that it was an easy way to dispose of numerous cases raising issues about statutory meaning under complex regulatory statutes. And I'm assuming everybody knows it, but Chevron's basically said that if the meaning of a statute is clear, then obviously everyone has to apply that. But if a statute is ambiguous or if it's silent on the issue, then the reviewing courts should defer to a reasonable or permissible agency interpretation. Now, the political context of this is interesting. At the time it was decided, the Reagan administration was taking a sharp turn towards deregulation beyond what Congress had authorized during the Carter administration, where there was a whole lot of legislative deregulation. And the Chevron case itself was an interpretation of the term stationary source in the Clean Air Act, which allowed basically the emitters, people seeking permits, to lump together all of their emissions from a single plant and get a permit based on that, which would allow them to make adjustments between different individual smokestack events in a way which was supposed to give them greater flexibility, but which environmental groups thought was really just a deregulation. And the statute, the director, the head of the EPA at the time, of course, was Ann Gorsuch, who was Justice Gorsuch's mother. So the Supreme Court deferred to Justice Gorsuch's mother in 1984. In the Chevron case, although some people say that, that maybe helps explain why he's such an opponent. He was always such an opponent of Chevron, but I'm not sure about that.
It's beyond the scope of your expertise.
Right. At the time the decision was issued, Republicans embraced Chevron as a way to facilitate this deregulation, but also theoretically as consistent with their sort of unitary executive theory and their notion that elections ought to matter. And that when an election, for example, Ronald Reagan's election was considered a watershed deregulatory moment, that ought to make a difference. And so if the agencies come in with a different attitude, that ought to be important in the law. And the Democrats, on the other hand, said it was illegitimate because it removed the judicial check on agencies, and it was inconsistent with just the notion of separation of powers, that it was for the courts to determine what the law means, and the agencies were supposed to implement that meaning. So basically that's how it lined up for a while. That is, Democrats hated it and Republicans loved it. And then during the Obama administration, maybe a little before, the political dynamic changed. And slowly but surely, Republicans became Chevron's most outspoken critics, while Democrats became its most ardent defenders, because it enabled aggressive regulation. And so one of my favorite examples is during the Clinton administration, actually, when the Supreme Court allowed the Bureau of Land Management to read the prohibition on taking an endangered species to include habitat degradation. And even though no species was actually taken in the common law definition of what it means to take, the Supreme Court said, well, that's a reasonable understanding of it in light of the context of the statute. And so as the opposition to Chevron from the conservative side multiplied, you saw even the House of Representatives repeatedly passing a bill called the Separation of Powers Restoration Act, basically just to overrule Chevron, claiming that it violated separation of powers. Now, what happened then at the Supreme Court was that the Supreme Court basically stopped applying it. It never really applied it in most cases under which it should have applied. And if you look at the votes on cases involving Chevron, basically the conservatives deferred when the agency did something conservative, and the liberals deferred when the agency did something liberal. So it was no different from business as usual at the Supreme Court. But the lower courts sometimes seem to be deferring more, that they would basically defer to regulations and also agency interpretations of their own the immigration laws and benefits laws, sometimes to the prejudice of those applicants and claimants, but other times basically just to the benefit of forces in favor of regulation. Now, so one of the things that was put forward before Loper Bright was the idea, well, what they ought to do with Loper Bright is Kaiserize Chevron. So Kaiserizing it refers to the decision from a few years ago, Kaiser, which maintained another form of deference. And basically the Supreme Court said, well, before you get to deference, you need to make sure that under the traditional tools of statutory construction, you can't arrive at what you consider a best reading of the statute.
Yeah.
And in Loper Bright, the Supreme Court overruled Chevron, said it was always wrong because it was inconsistent with the APA, but also said basically there's no such thing as a statute that where you can't arrive at a best reading, that there's always a best reading of a statute. And so the whole idea of not having a best reading and having ambiguity remain is just, the Supreme Court said it was just not a non-existent set. But the Supreme Court's basic view was that the Chevron always violated the APA, which tells reviewing courts to decide all relevant questions of law, interpret constitutional and statutory provisions, and determine the meaning or applicability of the terms of agency action. So that's basically, Chevron is now wiped off the books. But the Supreme Court also said that it cited Skidmore deference favorably, deference under the factors that the Supreme Court had deferred to agency interpretations pre-Chevron and pre-APA. Right. Now, so on the one hand, it seems like this getting rid of Chevron seems to be part of the Supreme Court's anti-regulatory effort. And in that point, the dissenters said in the Loper Bright case, that it makes more sense to leave construction of complex regulatory statutes to the experts. But the court allowed for deference under the Skidmore doctrine. And I want to just read a couple excerpts from the opinion to show how much deference there might still be. The court said that Skidmore allowed reviewing courts to, and I'm quoting from the court largely, resort for guidance and even on legal questions to the interpretations and opinions of the relevant agency, made in pursuance of official duty and based on specialized experience. And here's one that sounds almost like Chevron, and this Skidmore and Chevron were very similar. And the court said, when the best reading of a statute is that it delegates discretionary authority to an agency, the role of the reviewing court under the APA is as always, to independently interpret the statute and effectuate the will of Congress subject to constitutional limits, which sounds non-deferential. But then the court went on to say, the court fulfills that role by recognizing constitutional delegations, fixing the boundaries of the delegated authority, and ensuring that the agency is engaged in reasoned decision-making within those boundaries. By doing so, a court upholds the traditional conception of the judicial function that the APA adopts. And some of that is quoting from a law review article by Henry Monahan from 1983, which was a pre-Chevron discussion of administrative law under Marbury versus Madison. So that's basically what happened in a nutshell. And so it could be that the only difference is we don't cite Chevron anymore, or it could be a big difference. But I think the big difference is caused more by all the other malfunctions to the plane, not because it's run out of coffee.
That was an excellent summary, and thank you for landing the plane, so to speak, at the end.
Well, or crashing it.
That's right. I mean, to summarize a lot that you just said, statutes that Congress writes are often ambiguous because they can't think of everything that's going to happen in a given agency in a given context. And when it's ambiguous, when it's clear, none of this matters. But when it's ambiguous, there was kind of a thumb on the scale of the agency's interpretation, so long as it was reasonable. Maybe there's Skidmore deference now, which was pre-Chevron deference, but it seems that there's no longer that thumb on the scale of the agency's interpretation. As you said, Justice Roberts in Loper Bright is saying, no, the federal courts are to look at the statute and they are to come up with the best meaning. Ambiguous or not, the federal courts are the ones who decide, and what the agency decided in maybe their adjudication or what have you, we're going to consider that, but it's not worth that much. You don't get the thumb anymore. Is that right?
Well, I think so. I mean, obviously, we're not going to really know for a year or two when we see some more cases. But over the last 10 years, the Supreme Court has basically been reading statutes itself independently, even in cases where they were litigated as if Chevron was the issue. Now, they did remand 8 cases a couple of days after the Loper Bright decision, all cases in which the government had won and all cases in which the lower courts had cited Chevron. So I think the first test is going to be, how do those 8 cases come out? Are they going to come out the same? That is the government still going to win? Or are there going to be some reversals there where the government loses? And I think, it remains to be seen what happens with in the future. But my guess is that the Supreme Court is going to be business as usual, as it has been over the last several years, which is narrowly reading administrative authority and independently deciding on the meaning of statutes.
Yeah, but I want to turn to Barry now, but pivoting off something interesting you said in the history of Chevron was that the DC Circuit eventually came to see Chevron as a way to easily get off some of its agency challenges that were just overflowing the docket. It's one thing when you're the Supreme Court and you can choose your cases and you're taking between 50 and 80 a term, but the circuit courts have no such luxury. Barry, as an administrative law litigator pre-Chevron, what was it like litigating pre-Chevron? What were the arguments when the agency didn't get that thumb and that deference? And what do you expect is going to change in your practice after Loper Bright?
Well, first of all, let me make it clear that I was an extremely young associate.
Right, you were a fetus. That's right.
Barely out of law school, and didn't have any cases in the Supreme Court, but had a number of circuit cases. But at that time, you also have to remember that it was the late 70s. Most of the major laws that have resulted in the litigation that we've seen weren't even on the books. You had a few laws that the one I was involved in was the Surface Mining Act, but like the major environmental laws, Clean Water Act, Clean Air Act, Solid Waste Act, that created these regulatory programs that got challenged, really weren't on the books back then. So there weren't that many challenges, relatively speaking, like there were after that. And in the ones that we did, which were not in the DC circuit, which means courts in other circuits, district courts and courts of appeals and other circuits, weren't used to seeing challenges to agency rules. And we're kind of like, you want me to throw away this entire set of regulations? And so they were not inclined to want to do it anyway, at least in my experience. And the language, if you look at the cases that I was involved in anyway, it was very much Chevron-like language. You argued whether the statute authorized it, and they go, I'm not really sure. And the agency's interpretation is reasonable without citing Chevron. It was a kind of a Skidmore thing, but they were not, at least those cases, it was not, I think the professor said it was not that major a thing when Chevron came out. We were still litigating the same things. The difference was, and that I tell people is that, when you litigated cases as the circuit courts and district courts saw more of these cases, the courts did, they deferred a lot. It was more than a thumb on the scale. It was like, I don't want to deal with this. Yeah. I don't understand it. And if you argued anything that remotely sounded like dancing on the head of a pin about details, they were not interested. If you could argue something that was very clearly statutory, you have a good chance. But there weren't that many successful challenges based on, looking at the agency and looking at a very technical term that the courts didn't really understand or didn't really want to spend the time to understand and kind of didn't want to upset the apple cart in many ways.
We have a very different judiciary now, though. It's very clear that there are many district court judges and appellate judges who are willing to take that deep dive into these statutes. And correct me if I'm wrong, but Chevron, if you are a litigator, a client comes to you, they want to challenge a new regulation, you're going to tell them it's going to cost a lot of money. And at the end of the day, the administrative agency, the federal court might defer to Chevron. Under Chevron, they might defer to the agency interpretation. That is no longer your advice to prospective clients.
What I tell clients, what I told them before Chevron, after Chevron, because many don't understand this, you better make the record before the agency, before you go to court. And I think one of the things, professors, how much of an effect is this going to have? And my view is that it's going to have a big effect in a small number of cases, because the vast majority of cases aren't that complicated, and because it is amazing how people are not able to make the right record before the agency to get it before the court. They think it's like, many people think a rulemaking challenge is like a trial where you go and present evidence, and you don't. And they want to wait and go to court. And you say, no, you can't do that. You have to present all those arguments to the agency. And I think you even have to present, and I always do when I make comments, hey, agency, here's what your authority is and what it isn't. And make comments to the agency in rulemakings that point out the new rule that and what the best interpretation of the statute should be, to force the agency to kind of deal with that in the record, which then constrains what they can do in a court of appeals in a review.
But you're talking about notice and comment rulemaking when an
Right.
agency is going to promulgate new rules, and you better put all of your arguments in notice and comment during the period, is what you're saying, before you then bring it to federal court, assuming they've ignored your comments, I guess, is the
Right.
hypothetical.
And force them to answer that in the comment period.
But what are the small group classifications of cases then that you think are going to be largely affected?
I have been trying to figure that out. I mean, I think we have to look at the cases that are out there. There was a rule by the Department of Labor issued on what's an independent contractor. And I think that's one that's probably going to get reviewed. If you look at the series of and it was something I think we're going to talk about later, there have been a number of examples of agency rulemaking efforts that every administration have changed. There's one called the Water of the United States rule. What's a water? Purpose of the Clean Water Act. That was an issue when I worked in the first Bush administration, and every administration has changed that.
Right.
And one thing the court said here is that, when there's and the professor said it, when there's a best interpretation, a permissible one doesn't matter. And I think there's going to be some fixed interpretations of some of these things as they come up when administrations change, that are going to say you can't. This is the best interpretation of this statute. What's a water of the United States, or what's an independent contractor versus an employee? That you can't simply change because you have a better idea. And they're going to become there's going to be a few of those kind of cases that are going to become fixed interpretations,
Right.
that Congress is going to have to change if anybody wants to change it. It can't just be the agency.
In practice, and the professor mentioned it, there was this idea that with a change of administration, you can have some maneuverability on these regulations. But now there is nothing that stops litigants. You said a small amount of cases, we'll see. There's nothing that stops litigants from creating their record and then shooting their shot with a federal judge. And once a federal judge, or certainly a circuit, then says what the statute means, there's no changing that anymore. Administrations can't come in and reinterpret that. Is that
Yeah, I
correct?
mean, that would be the argument, that and of course one can try to go to a different circuit and then create a conflict, but in theory it means that when there's a best interpretation, you can't come back with another permissible interpretation and change it. And
so,
I think that's going to change. Some of these major rules that change every administration are going to be subject to that, I think.
And so, not to put more on this upcoming election, but then it would seem that a lot of the decisions that are made on what statutory agency, what agency statutes mean in the coming years, they might bind us for a very long time. They
might, and it could go either way. I happen to think, and I'd love to hear the professor's views on this. I happen to think that what is a conservative judicial philosophy is not necessarily the same as what's a Republican conservative philosophy. And there could well be examples of cases where where maybe the Trump administration comes back in, even under when Trump was in, they lost a considerable number of cases before conservative judges where they tried to change a rule and they just didn't do it the right way. And it'll be interesting to see how that plays out, if there's a change in administrations.
I do have a question for Professor Beermann. Before we do, we have a question in the chat. It's about immigration, which really is about case-by-case adjudication. We're going to get to that, but I think I want to wrap up our thoughts on the regulations first, because in immigration and other areas, there is a lot of agency regulation as well. Most of what we've been talking about so far is challenges to agency regulations, not precedential case-by-case agency adjudication. And so, Professor Beermann, I mean, I'd like to have your thoughts on how you think the future is going to look now, whether the floodgates of litigation have just opened, and whether or not we are really in the era where federal judges tell us for all time what statutes mean. But I'm also curious, I know there were other administrative law decisions that were issued this term in the airplane. So what is the effect of those on our new administrative law world?
Hey, it's very interesting. And I really appreciate Barry's comments and experience. He has much more experience. I was clerking when Chevron came out for a Court of Appeals judge who was very interested in administrative law. And I do remember talking about the Chevron case with him. This was Richard Cudahy on the Seventh Circuit, he was an energy lawyer who was very, very interested in administrative law. And it was interesting. But so one of the things Barry said was very interesting, had to do with the flexibility that agencies purportedly had under Chevron. And there was one of Chevron's offshoots was a case called Brand X. And although it really was implicit in Chevron itself, basically, when you had this notion of an ambiguous statute, and you had then the agency's permissible or reasonable construction being approved, what that meant was that if a new administration came in, or if the agency just changed its mind, or the circumstances changed and they were convinced, they could then adopt another permissible or reasonable interpretation. And that could also be affirmed under Chevron step 2, because that's exactly what happened in Chevron. I mean, some people said, oh, this Brand X is terrible because it lets the agency ignore the law, but that's exactly what happened in Chevron. Chevron was basically different, the EPA at different times adopting different definitions of what it means to call something a stationary source. So under the Brand X case, the agency would have the power to adopt another reasonable interpretation of a regulation, and that could also be affirmed on judicial review without having overruled the prior affirmance of the earlier approval. And I guess we want to wait and talk about adjudications, because it is completely different with regard to adjudications. Yeah. Maybe we'll see, because there's an important case in the adjudicatory area called Fox Television. But so now, when the Supreme Court said in another case, the Meade case, that because Chevron doesn't apply, we're going to use Skidmore, Justice Scalia dissented and said, well, that means you're going to freeze the rules, that the agencies won't have that flexibility anymore. Because Justice Scalia was a big, supporter of Chevron, although, truth be told, if you count the cases, he deferred less than any other member of the court. But he talked about Chevron as if it was a great thing. He just didn't like to apply it. So now it seems like if the agency wants to change its mind, if their interpretation had been approved previously, they're going to have to convince the court to overrule its prior decision. Now, if the court hasn't, if the agency's earlier regulation was never reviewed, then of course they still have that flexibility. But here's the rub. What if the court approves an interpretation of a regulation relying on the Skidmore factors? That is, what if the court says, well, we're not so sure what this statute means, but the agency is telling us that for policy reasons and for reasons of consistency, it really wants to go with this interpretation. And it is longstanding. The agency's reasoning is persuasive, and they've done a thorough job of documenting the reasons for it. So we're going to go ahead and approve that. In my opinion, that flexibility in the agency ought to remain, although I have a feeling it won't. But right. That's when I've been writing about Chevron, I've been saying for a long time that they ought to preserve that aspect of Chevron. So now, so I think Barry is correct that it's going to be more difficult now, perhaps, for agencies to change their mind based on a new administration coming in. And one of the things you could say is, and this is something that I've thought about, that this could moderate administrative law in a certain way. And he talks about the conservative judicial philosophy. So basically, if you have an administration come in that takes an extreme view about regulation, one way or the other, that the fact that judges are in charge now, rather than agencies, could mean that the agencies won't be able to go as far off the beaten path as they might under Chevron, perhaps. But I do want to say that one of the things that happened in the Loper Bright case was Justice Gorsuch wrote a long concurring opinion in which basically he downplayed the importance of stare decisis, or precedent, in decisions, basically saying our job is to get the law right, regardless of what we or our predecessors have said. Basically licensing the courts to ignore precedent in the future, because we got to get it right. And that's a new kind of conservative judicial philosophy. It's an originalist judicial philosophy. It says basically that continuity or consistency or adherence to precedent is much less important than getting the answer right. And it presumes, of course, a pre-modern view of law that there is a right answer somewhere floating out in the ether that good judicial reasoning will get them to.
And yes, Barry, please go.
I was going to say, the other thing we just had what the professor said, and I think he's right. You have to distinguish between, what does the statute say and allow the agency to do, and what does a regulation do? Challenging an agency's interpretation of its own regulation is a very different animal than
Right.
challenging its interpretation of a statute. And there may be statutes that give an agency, they're not ambiguous at all. They give the agency discretion to, the simple example I use is statute says you can regulate blue eyes. Well, does that mean light or dark blue eyes? And maybe that's left up to the agency as to what it means. And one administration could come in and say, we think it should be light blue eyes for these 12 reasons that are in the record. And then somebody else comes in and says, we want to reopen this. Is that really the right decision? And now the record supports interpreting that term differently, because as a technical matter, dark blue eyes should be included as well. So that's very different than, I think, than saying the statute is ambiguous. The statute can give an agency discretion, and then it can maybe change its mind somewhat. But as the court said, ambiguity doesn't mean you have the power to do anything you want.
Right, and that actually answers one of the questions we have. And what are your thoughts on how challenges to regulations that create extra statutory requirements will fare now that Chevron has been overturned? And to me, I think that's a bit of a red herring. In your hypothetical, you couldn't regulate brown eyes because the statute says blue eyes. That's an ultra-virus statute, and that's an ultra-virus regulation vis-a-vis the statute. And I'm not sure, do either of you think Chevron has anything to say about that, or will affect such an argument? Will it make it easier, harder? I mean, if a regulation is doing things that's clearly beyond the scope of the statute, that's...
Go ahead, Professor, you go first. You're the scholar. I'm just a litigator.
Well, I don't know. The litigator may have a better view of what really happens in the world, but I would say that, but that's why I think that the overruling Chevron is more like the coffee. The engine is basically, first of all, the major questions doctrine, which says that if an agency goes far beyond what is clearly authorized in the statute, and it's a big deal, that is, it has important economic and political ramifications, we're going to presume that the agency lacks the authority to do that unless Congress explicitly tells them so. And also, if you look at the general way that the Supreme Court has been interpreting even clear regulatory authority, like the Waters of the United States case that Barry mentioned earlier, even Justice Kavanaugh there had to say, you're reading this a little bit too narrowly. You're going to cripple the EPA's ability to take care of serious environmental problems. And by the way, there's been studies that show that the EPA's ability to deal with water pollution has gone really down significantly under the new understanding of the waters of the United States. There's a lot of pollution problems that can no longer be dealt with at the federal level. So, so you have a court inclined to read things narrowly. And then you have, of course, the ability of the challenger to be able to choose a forum. So they go to the Fifth Circuit and get a circuit that agrees with that philosophy. And so I think that's more where the action is, just narrow readings of regulatory statutes. So that, and the more important it is in terms of being politically and economically important, the major questions doctrine and related ways of looking at things make it more likely the courts are going to read things narrowly. But, the major questions doctrine also developed as an exception to Chevron. So they were already free and clear of Chevron in that. And they were deciding, again, as I said, like the Sackett case, which was about the narrow reading of the waters of the United States, they decided that while Chevron was still on the books. Right. So, and the Fifth Circuit hadn't had any trouble in the last several years of deciding things narrowly. So it really depends, and I hate to be this blatant about it. It really depends which political party the judges come from, who gets to appoint the judges. So because it's pretty clear right now that there's a big divide among judges. And even though it's true that the Trump administration lost a lot of cases in front of conservative judges, that was because the Trump administration just showed a complete lack of competence in how they did things. If you were a supporter of their policies, you should have been really upset at them because they were so bad at getting things done. Whereas, if you have good lawyers and good and competent officials, you could get a lot more done. Right. And that was their biggest problem. So it wasn't that I don't think that it was just, they had just gone so far off the rails in terms of what you have to do to get something by serious judicial review that they couldn't get things approved. I still think that overall, the party of the judge is a big determinant in how controversial regulations are going to get treated. And that's on both sides. I don't mean to single out Republicans for being narrow, because Democrats tend to be more, more forgiving of administrative authority. And I thought that it seems so knee-jerk reflexive that the Democrats on the Supreme Court had a dissent in the Loper Bright case. And they wrote a dissent, which I understand was passionate, but was, in my view, was just wrong on the law. And I've been, again, I'm consistent with the Democratic position about Chevron since 1984, which is that it was really wrong on the law, but it was a good policy when you had a president whose agency actions you agreed with.
Well,
and I would say, in answer to your question, Kevin, ultra vires, my view, and when I litigate cases, I always want to argue it's inconsistent with law. It may
Right.
be inconsistent with law because it's ultra vires, but ultra vires means it's beyond their authority. Well, if the statute doesn't authorize to do it, I would argue that's ultra vires. An
That's right.
ambiguous statute that doesn't say you can do it means you can't do it unless Congress tells you you can. So I think go ahead.
For all the immigration listeners, great decision out of the Fourth Circuit in the naturalization context last week, in which the Fourth Circuit goes through and explains this very thing about how USCIS has gone beyond the scope of the naturalization statute in the added requirement they're adding for naturalization, which is not really an agency deference type thing. There's a question about, so Loper Bright Chevron only applies to regulations, not case-by-case precedential adjudication. That's not accurate. This all applies to case-by-case adjudication. We just haven't really talked about it yet, and it's very relevant in immigration. And we're going to get to that in a second. We've got a lot of time, and we're doing great. And I myself am already learning a lot. But I don't want to leave the challenges to the regulations without talking about corner posts, Professor, and some of the other things, because Loper Bright wasn't the only case. There's Jackassy, and I can never say it right. There's Jackassy as well. There's corner post. This term was a full-on assault to the administrative state as we know it. And so I want to give both of you a chance to kind of talk about those other decisions if you have anything to say.
Well, corner post basically said that if there's a regulation on the books that you're newly subject to, either because you were born after it was promulgated or because your business started or moved into a new area after it was promulgated, that basically if there's no specific statute of limitations in the statute under which the rule was promulgated, then the federal 6-year statute of limitations kicks in, and you can continue to challenge that regulation on its face for 6 years after it first affected you. That is when your claim arose. Now, many regulatory statutes have a 60-day requirement. There's even a catch-all statute that Barry was kind enough to point out that encompasses many agencies that say that if you want to do a facial challenge to a rule, you have to challenge it within 60 days. There's a loophole and there's a complication, though. The loophole is that many of those statutes say unless the grounds for challenging it arose after the 60 days expired, and then you have 60 days from when the new grounds arose. That's still a pretty short period, but it still leaves it the possibility open for a later challenge. The complication is, what about applied challenges? That is, for example, suppose you're in a new business and some old rule gets applied to you, and so you got an order issued against you, for example, to comply with some rule that's been on the books for 40 years, but it's the first time they've ever done anything to you about it, and you have a certain amount of time to challenge the order that's been issued against you on judicial review. Can you raise the validity of the rule from 40 years ago in that challenge? Well, it seems like there's a sort of a well-known case from 1977 from the Second Circuit, the Nova Scotia Foods case, which seems to say that when a rule is applied to you, you can raise defects in the promulgation of the rule as a defense to having the rule be applied to you, even after the 60 days are long expired. So it seems like if it awaits to be seen, but it might be that the court is going to be willing to revisit a lot of rules that were finalized during the era of Chevron when they're applied to someone new, and then if you sort of reduce the value of stare decisis, that even gives the current courts much more freedom to change, to ignore what the courts have said in the past about the validity of rules. So there is a chance that we could see a lot of old rules getting re-challenged. And that's one thing we've seen a lot of in the last several years, which is that what seem to be like settled legal doctrines suddenly become open to challenge. Surprising rulings about the structure of the administrative state and all sorts of things. So that remains to be seen, but I think that the corner post, the spirit of it at least, opens up the possibility of a lot more challenges.
And I mean, and the text of it as well. I mean, we have to go through a deep dive. I know Barry has done a little bit, but if a statute is tethered to the APA's statute of limitations, right? Correct me if I'm wrong. Corner post allows a challenge to that regulation starting when the plaintiff was affected. And that is a huge deal for all regulations that we thought were settled regulations. Now, you can do as applied, as you said, Professor, based on that 1970s decision, but to invalidate the entire regulation, it is open season. If it's an APA tethered statute of limitations, candidly, as an immigration attorney, I don't even know what immigration regulations are tethered to. I have a feeling it's the Hobbs Act, but I'm not sure. And the Hobbs Act would have its own statute of limitations. But for big immigration litigators and litigators in all spheres of agency regulations, corner post is, I mean, the dam has burst, it would seem.
I said to somebody that they said, if I were still in the government and an agency had said to me, what should we do about this corner post thing? I'd say, get a bigger budget.
Yeah, right.
You're going to need it. I think that's true. I mean, I think it is going to open up a lot of that. The cases we were talking about, there's about 40 or so, and some are cited in both the Solicitor General's brief, and I think in one of the dissents, I think we posted that material, that have specific days by which you have to challenge the dates from publication in the Federal Register, which is not tied to harm. And as you point out, that's a question of, what if you came in existence after more than 60 days after the regulation was promulgated? Could you challenge it then? And there are a couple of cases in the DC Circuit that have addressed that, one of which I mentioned to the other speakers when we were on the phone. Kavanaugh was on, that said, no, you can't challenge it just because you came in existence afterwards, because that would ruin Congress's intent that these regulations be settled. You can't do a facial challenge.
Right.
But you could still potentially do an applied challenge, and then you peel that onion back and say, what does that really mean? It's being applied to me, but am I saying it can't be applied to me because it was arbitrary and capricious when it was promulgated? It wasn't supported by the record. Is that really, it's in an ad-applied context, but it's really a facial challenge.
As an aside, and not to even get a response, but Professor Beermann, I'm not sure how you're teaching the major questions doctrine. All I know is it means I still have student loans. So I'm not sure how you are, only partially a joke. But no, admin law, it's the Wild West right now. I'm sorry, I don't know how you find that Missouri has standing. That's a whole separate silly. But I want to pivot a bit to case-by-case adjudication and some of the immigration questions we have. But immigration, of course, is not the only administrative agency that makes its rules in part by case-by-case adjudication. The Supreme Court in Loper Bright said that its other decisions that had relied on Chevron they were still good law. The chief didn't really explain why, but he just kind of said it. But that, that's the Supreme Court, and that's how it works. But, there is the circuit doctrine that, of course, one panel can't overturn another panel. But if the Supreme Court has done an intervening change of law that's so fundamental, and then another panel can say, you know what, that line of cases is bad law. What is the situation with immigration precedent and other agency precedent that at first had relied on Chevron deference to the Board of Immigration Appeals or another agency tribunal? They had deferred to that 20 years ago. And now all this precedent has been built on top of it, say in the crime involving moral turpitude context, like we had been talking about before we went live, Professor. What happens to all that precedent that may have been infected from the start with Chevron deference?
Well, you packed in a lot into that one.
Yes, I did.
There's a few different issues that pop up there. One issue is, let's take the paradigm case that you're talking about. You have a regulation that I'm sorry, you don't have a regulation. You have an interpretation on adjudication
yes.
by the by the Board of Immigration Appeals. Okay.
Yes.
So they came up with their interpretation, and it was approved under Chevron deference. Now, the Supreme Court said that it's not enough to overrule a precedent just for the fact that it was arrived at under Chevron deference. So, but let's suppose that the Board of Immigration Appeals now says, you know, we're taking a different view of that. And we think that actually we should narrow or broaden whatever you want, whatever they're doing, the category of crimes that are considered crimes of moral turpitude. I don't know anything about this doctrine, so that's about as much as I can say. But now, at this point, I think two things come into play. First of all, there's the Supreme Court's Fox Television decision from several years ago, in which the FCC changed its view on what it considered indecent language on broadcast television during the family hour. And it used to say that non-literal, non-repetitive uses were not indecent. And then it decided that non-literal, non-repetitive uses would be considered indecent. And they would discipline broadcasters for allowing that. And the Supreme Court on judicial review of that said, well, you know, that's as long as they point out that they understand that they're changing their rule and they have good reasons for the new rule, that's enough to justify them changing it. And I think that applies to rulemakings also. That is, if the agency engages in a rulemaking or engages in a reinterpretation in the course of an adjudication and recognizes that what they're doing is a change, that is subject to traditional judicial review. Now and as long as the new rule is also not arbitrary and capricious, that rule ought to be upheld. Now that sounds a little bit like Chevron, but it's different because it's in a case-by-case adjudication.
Right.
Now, if you add to the immigration puzzle here a regulation, suppose that there had been a Department of Justice regulation issued about an issue that comes up in an immigration adjudication.
Yep.
Well, then it seems like the agency can't back off what the regulation says the law means without going through a new rulemaking. And I actually think that was always the case. So I'm not sure that this decision is going to be that impactful on agency flexibility, unless the court reconsiders and says, you know, we used to say agency flexibility, but now, you know, as part of its flexing its muscles and wanting to take control over everything about the law, maybe now it's going to say, once we approve something on judicial review, that's the end of it. They can't change it. But that would be a major change in the way they've treated case-by-case adjudications conducted by agencies like the FCC and other regulatory agencies.
Well, you had mentioned that after Loper Bright, the Supreme Court actually remanded a handful of crime involving moral turpitude immigration cases because they had relied on Chevron. And I guess I'm a bit confused a little bit about something you just said. It would seem to me that these agency tribunals, like the Board of Immigration Appeals, that can issue precedential decisions that bind nationwide in case-by-case adjudication, but then they apply it nationwide. Aren't those just advisory opinions now? Aren't those, what are those worth after Chevron? It's just another thing for the circuit to consider when interpreting and deciding what is a crime involving moral turpitude. What is this other ambiguous statutory phrase in the agency context? Is that not correct?
No, I think that is correct. There's two different situations. One is if a case comes up for the first time to the Court of Appeals, right? And the Court of Appeals, you know, let's say a year ago, it came up to the Court of Appeals for the first time, a particular issue, whether a specific crime is a crime of moral turpitude under a particular state's statutory structure. And that the Board of Immigration Appeals had said, yes, it is. And the Board of Immigration had said that. And then the Court of Appeals said, yeah, okay, that seems reasonable under Chevron. Now a case to the Supreme Court, and the Supreme Court remands and says, we want you to reconsider that without applying Chevron. Okay, so there's no precedent standing in the way of the Court of Appeals in that case. That's a different case from if 5 years earlier they had the exact same issue and they'd already decided that it was a crime of moral turpitude. They'd already approved what the board had said. Now, in that case, the Supreme Court is telling the Court of Appeals to possibly overrule their prior decision. That's a different question. In other words, so if the 3 cases or 4 cases that they remanded were cases of first impression at the Courts of Appeals, then you have no precedential bar at all. You're just going to review what the
Right.
Board of Immigration Appeals did without regard to any precedent and without regard to Chevron. if there was already precedent on the books, then I do think that the courts of appeals may say, well, look, that precedent isn't really binding precedent anymore because it was
Right.
issued under Chevron. And so we're going to reassess what the Board of Immigration Appeals did and determine independently whether we think their interpretation was correct. And the government might still win or the government might lose. But they at that point, that's the interesting question is, are they going to say that if we already had a precedent on this particular issue, we can now ignore it?
Right.
I don't know the answer to that. That remains to be seen. In the next year or so, we'll know more about that.
We're getting questions on this, and I want to, I guess, turn it to Barry as also a litigator, obviously not in the immigration context, but this is my thought. What do we do now post Loper Bright with our decisions? Well, you dig back if in the context where the circuit has already decided that that exact statute is a crime involving moral turpitude, or has already made a decision on some sort of agency case-by-case adjudication precedentially. You dig back as far as you can go to see whether or not the initial decision relied on Chevron deference. It could have been in the CIMT context that the circuit looked at it, made a determination based on the statutory text, and then Chevron has nothing to do with it. But if many years ago the initial basis was Chevron, it seems that is open to challenge. Is that
with Chevron step 2, you mean?
Right, with Chevron, with it, right. Everyone said it was ambiguous, and then many years ago, the circuit said, okay, well, that was a reasonable interpretation. If it was ambiguous all of those years ago, then the circuit would have then gone to Chevron step 2, and that's open for relitigation, is it not?
It seems to me like it would be. I guess I've not challenged that many regulations as applied in an enforcement context. And, I certainly don't know immigration law at all.
Yeah.
The 3 areas I stay away from, including patent and tax. But, I don't know whether this matters, but the court did say, and you tell me whether this matters, Congress could appoint an agent, an endow the agent with the power to make findings of fact which are conclusive, and where the law and the facts are so intertwined that there is a functional deference that goes on there. I don't know whether that principle would apply in your context or not, but I found that to be really interesting because that's really talking about adjudications. I think I may be wrong.
Yeah, Kevin. Yeah, I think that's right, Barry. And also, though, Kevin, this exact question came up during the Chevron era. That is, there were pre-Chevron decisions, and the agency tried to reverse itself, and the Supreme Court basically followed what seems like a logical line, which is, well, if in the earlier decision we had decided independently what a statute meant, then the agency can't change it. But if in the earlier decision we had applied the Skidmore kind of factors and deferred, then maybe it is open for the agency to change it. So that's why some of that flexibility may survive. But I'm a little skeptical. But I do think that basically any decision that was decided under any decision where the court relied on Chevron step 2, whether it's the Supreme Court or the courts of appeals, I think those decisions are open, despite what the Supreme Court's saying they're not in the Loper Bright opinion. I think they are open to be reassessed, and that I wouldn't be surprised if some lower courts said, well, look, we approved this prior under Chevron step 2, but now that the Supreme Court has told us we have to arrive at the best reading of the statute, we don't think that's the best reading anymore. So we'll see. It would seem illogical to give precedential value to something that the court rendering it didn't intend to be binding in that way.
Right. We're getting a lot of immigration-specific questions that I do think are beyond the scope of this panel, but I'll just say it based on what you both seem to be saying to me. To all the listeners in immigration, if the immigration statute is ambiguous, then the BIA's definition of that ambiguous statute, particular social groups, crimes involving moral turpitude, particularly serious crimes. What is a parole, which is one of the questions. I mean, so much of the INA is ambiguous, and the BIA's interpretation of that might get upheld by the circuits. If a circuit has said, we agree that that's exactly what the statute means, Chevron doesn't, Loper Bright doesn't matter. But if the circuit has just been deferring to what the BIA has been saying all these years, it's open season for litigation. And like you say, Professor, we're going to find out, and Barry, we're going to find out in a year or two as these decisions start coming. And it might be different based on the circuit. Immigration law has language about how you're supposed to defer heavily to the Attorney General. What does that mean? I don't know if we know. There is
Because
a non, yeah, please, Barry.
I was just going to say the other thing, and I think this applies everywhere, is, and we were going to, if we have a few minutes to talk about it, is, using traditional tools of statutory interpretation to understand or to determine what Congress said, not, which isn't the same as what they meant, what they said in the statute. And I think there's going to be a lot of people who think that, okay, well, let's go look at a Congress report, let's go look at a conference report, let's look what the sponsor said. But really what you have to look at is the entire statute that was passed and see how all those things fit together. And I think a lot of people don't do that quite enough. And that's what this court's saying to do. Look at the whole statute. It may not just be one section, it may be 50 sections. And your point about, the Attorney General, I would say that, if the statute, if Congress said in a statute, defer to the Attorney General, he has a lot of authority. This immigrations may be different because they have so much authority, that it could be that Congress intended that the Attorney General have that, or said the Attorney General has that power. And so when we read everything else, we have to read it in the context of that. But those statutory terms, I think people you have to pay attention to what the real tools of statutory construction are.
And I've been talking about that on my podcast. The 11th Circuit has been flirting with just that. That is that immigration talks about deference to the Attorney General, so maybe immigration special. We're talking at the beginning of this. I want to, in the limited time we have left, not just because it's, of course, not just immigration. There's a question that I don't know the answer to. I don't know who wants to take this, if it's even possible. How can regulated businesses possibly make long-term plans or investments? Any practical insights for practical risk mitigation? I guess the idea is businesses don't know whether it's in the marijuana industry, as somebody also just put in the chat, or another industry, there's no longer certainty in the regulatory world, or is there? Is that too worrisome?
I don't think that's changed. I think that exists with or without Chevron. You look at the energy world. President Biden really wants to push renewable energy, and he's done a lot to do that. And the Trump position is, let's be energy independent and focus on fossil fuels. How do you make investment decisions? I don't know. I think that's a much more macro issue for investors than just Chevron and that sort of thing. But that's just my view, and I think it's very uncertain.
And it's hard to know which way Chevron deference cuts, because Chevron deference on the one hand allows for more gyrations from administration to administration, but on the other hand, it mutes the effect of changing the composition of the courts. So it's very difficult, and it's in an era of political division, the way that we're in right now, where the law is more likely to gyrate. It is much more difficult to make any sort of long-term planning that way.
Yep, I think that's true.
We're just about at the hour point. There are some very specific immigration questions in the chat that I'm not sure all of them are about Chevron deference anyway. I've put my email in the chat if anybody would like to email me specifically about those immigration questions, because I'm a total immigration nerd. For the immigration people, and there is an election in November, I would remind everybody that the DACA decision came down to Justice Roberts on a different court, saying that the Trump administration violated the APA. So administrative law is very much important and on the docket, and that's just in the immigration context. Before we leave, and I hope that we got to a lot of questions, I did try my best. I'd like to give the floor to both of you, starting with Barry, if there are any final thoughts that you'd like listeners to have about this new world we are walking into in administrative law.
I'll just say two things. One is, if you're a lawyer and you practice and you have clients, don't look very carefully at the statutes and the regulations you're looking at. Don't just jump to the conclusion that you can challenge everything right away. I think there'll be a lot of people disappointed by that. You have to really be careful about that. And I think that's probably the best thing I could say. You have to be careful. It is big, but it is not necessarily an earthquake. You have to read things carefully, and you have to read the statutes very, very carefully.
And you, Professor?
I would echo that, and I would say that the interesting thing to me is whether results of cases are really going to change, and whether some of the judges are going to feel freer because of the end of Chevron to more carefully scrutinize what agencies do, which in the regulatory area, and since agencies tend to want to regulate more than Congress does right now, that that could be a negative if you're concerned about environmental and health and safety and things like that. But it's going to be very interesting for immigration lawyers because although obviously you have to be cautious, when you're fighting for someone's virtually their life, you pull out all the stops. And so insofar as you now have new tools, or basically you're less restrained in what you can argue about what the statutes mean, I think it's careful work at statutory interpretation could make more of a difference than it has in the past, where the court could just basically say, well, you have good arguments, but Chevron deference means we can't address them. But thank you, Kevin, because
Thank you,
I
Kevin.
do recognize you from your years at Boston University, and it's a pleasure to be on this panel with you, and also with Barry. And the ABA is a great organization that I'm active in the administrative law section, not in the immigration law. But it seems like we have a lot of commonalities that we might be able to join together and do some work on this, on these issues going forward. So thanks very much for everyone for including me.
Yeah, thank you very much.
You stole my thunder. Thank you to the ABA. Thank you to both of you. It was an honor to be on this panel with you. Thank you to the ABA Civil Rights and Social Justice section and the Immigration Law section for putting this together. It was a pleasure. Have a great day, everybody.